Study Session 1. The Nature of Crime and Delinquency. Introduction. In this study session, we will examine the concepts of crime, juvenile delinquency, and justice reforms. We will also examine the characteristics of crime, causes of crime, and delinquent behavior, as well as the differences between the juvenile and criminal processes. It will also look into the juvenile. Learning outcomes. After you have studied this study session, you should be able to 1. Define and use correctly the term in bold: crime, juvenile delinquency. 2. Enumerate the characteristics of crime. 3. Describe the characteristics of juvenile justice system. 4. Differentiate between juvenile and the criminal process. 5. Discuss the juvenile justice reforms. 6. Point out the causes of crime. What is crime? Many scholars, including criminologists, define crime in different ways. Technically, crime is any violation of the criminal law. This definition is inadequate when we consider other types of crime. Example, white-collar crime. Although there is no single compelling definition of crime that is acceptable to all criminologists, this lecture will, however, define crime as an act that violates the criminal law and is punishable by the state. Criminal laws are formalized or codified norms, which are rules that make explicit certain social expectations about what is appropriate behavior for particular people in specific situations. Conklin, 1998. Crimes, which are violations of these codified norms, are treated as offenses against the state rather than acts against specific individuals. Characteristics of crime. Durkheim, 1933, asserted that punishment is the defining characteristic of crime. He therefore identified 3 main characteristics of crimes, such as criminal intent, excuses, and justification. 1. Criminal intent. Crime usually involves criminal intent, which is the will or conscious desire to commit an act that violates the criminal law. For instance, an act that violates the law and causes harm may not be treated as a crime by the legal system if criminal intent is absent. 2. Excuses. The law allows several excuses and justifications as defenses to criminal charges. Excuses which deny criminal intent include the insanity defense. The excuse that one committed a crime because of drunkenness or influence of drugs is less likely to exonerate a defendant than to reduce the seriousness of the charge for which he or she is guilty. For example, ignorance of the law is an excuse that is accepted only under care circumstances. 3. Justification. This involves a defense that the law allows a person to act in a particular way. Self-defense against an offender threatening serious bodily injury is permitted if the potential victim uses no more force than necessary to prevent the harm. The defense of duress is the claim that another person coerced one into committing crime. Stealing a bicycle because someone forced you to at knife point is not a crime. The justification that one had to violate the law to avoid the threat of some greater harm from a non-human force is called the defense of necessity. Stealing a car to escape a dangerous situation is an example. Types of crime. Many diverse forms of behaviors are classified as crimes, with the only major common thread being a violation of criminal statute. It is impossible to look at all crimes. We will therefore examine the more important ones. You should keep in mind that the following categories are not mutually exclusive. There is an overlap among them. Organized crime. Organized crime is a large-scale operation. Illegal activities are carried out as part of a well-designed plan developed by a large organization seeking to maximize its overall profit. Zastro, 1996, and Berger, 1999. Activities that lend themselves to organized crime include illegal gambling, drug dealing, fencing, receiving and selling stolen goods, prostitution, and extortion in the form of selling protection. Large-scale operations are more cost-efficient than small-scale operations in certain illegal activities. For example, in drug trafficking, drugs are smuggled into a country and distributed on a large scale, with corrupt officials being paid off to reduce the risk of arrest and prosecution. A major characteristic of organized crime is that many of its activities are not predatory, such as robbery, which takes from its victim. Instead, organized crime generally seeks to provide to the public desired goods and services that cannot be legally obtained. Drugs, gambling, prostitution, loaned money. For its success, organized crime relies on public demand for such illegal services. White-collar crime. The term white-collar crime was first used by the sociologist Edwin Sutherland to refer to a crime committed by a person of respectability and high status in the course of his occupation. Sutherland, 1949. Embezzling, padding expense accounts, stealing from an employer, and evading personal income taxes all fall under this category. So does the misuse of public funds by government officials, accepting bribes, padding payrolls, and the likes. One difference between white-collar crime and common crime is that white-collar crime seldom involves force or violence. Embezzlement is an offense in which an employee fraudulently converts some of the employer's funds for personal use through altering of company records. It occurs at all levels of business, from a clerk stealing from petty cash to the head of a company stealing large investment sums. Many cases go undetected or unprosecuted. White-collar crime also involves computer-related crime. This involves illegal use of computer technology. For example, people who have access to a personal computer with a modem and the correct password can transfer millions of dollars anywhere in the world. Victimless crimes. These are violations of law in which there is no readily apparent victim. In truth, the people who commit such crimes are themselves both offenders and victims. Victimless crimes include prostitution, vagrancy, pornography, gambling, drunkenness, curfew violations, loitering, drug abuse, fornication, and homosexuality between consenting adults. Note that some of these actions are illegal in certain jurisdictions and legal in others. In other words, because public opinion about such activities varies considerably, the laws regulating victimless crimes differ from place to place. For example, in United States, gambling is legal in a few locations, including Nevada and part of New Jersey. Prostitution is legal only in part of Nevada. Homosexual behavior among consenting adults is illegally restricted to about half of the states. Criminal penalties for victimless crimes may do more harm than good. For example, treating someone arrested for homosexual activity as a hardened criminal may well damage the person's self-concept and status in the community. Sex offenses. Sex offenses include rape, prostitution, fornication, sodomy, homosexuality, adultery, and incest. In sex offenses, many victims are reluctant to report the offense because they believe they have nothing to gain and more to lose by making a report. A danger to society of underreporting of rape, for example, is that the rapist is less likely to seek out other victims. However, certain sex offenses, such as incest, rape, and homosexual contact with underage, incite considerable repugnance among the general public, which results in harsh punishment for offenders. Unfortunately, less attention is given to helping the victims cope with their exploitation or to rehabilitating the offenders. Homicide and assault. Criminal homicide involves the unlawful killing of one person by another. Criminal assault is the unlawful application of physical force on another person. Most homicides are unintended outcomes of physical assaults. People get into physical fights because one or both is incensed about the other's actions and decides to retaliate. Provoking actions may include ridicule, flirting with the other's spouse or lover, and failure to repay a debt. Fighting is often an attempt by one or both to save face when challenged or degraded. Homicides frequently are crimes of passion occurring during a violent argument or other highly charged emotional situations. Yet, some homicides are carefully planned and premeditated, including gangland killings, killings to obtain an inheritance, and mercy killings. Homicides are also associated with robberies, during which the victim, the robber, or a law enforcement official may be shot. Because of the averted physical damage from assault and homicides, these crimes generate the most fear. For instance, the police have a higher arrest rate, around 70% in homicide cases, than with any other crime, partly because they devote extensive attention to murders. Theft. This category of crime refers to illegal acquisition of someone's property without the person's consent. This encompasses crimes that involve theft of property belonging to others. Property crimes range from burglary to larceny theft, auto theft, and pickpocketing. People who fall under this category of crime are described as professional thieves who engage in confidence games, forgery, expert safe cracking, counterfeiting, extortion, for example, blackmailing others who are involved in illegal acts, and organized shoplifting. Sutherland, 1937. Professional thieves use sophisticated, non-violent techniques. For instance, their crimes are carefully planned and they tend to steal as a regular business. Apart from the professional thieves, we have the semi-professional thieves who engage in armed robbery, burglaries, holdings, and larcenies that do not involve much detailed planning. Some semi-professional thieves work alone, holding up service stations, convenience stores, liquor stores, and the likes. Semi-professionals often wind up spending substantial portions of their lives in prison because they commit the types of crimes that are harshly punished by courts. They adjust fairly well in prison because other inmates often have similar backgrounds, lifestyles, and views of life. However, as a group, they are poor parole risks. Juvenile delinquency. In general, children under the age of 18 are handled by the juvenile courts, either as status offenders or as delinquent offenders. A status offense is a violation that can only be committed by a juvenile, such as running away from home, truancy, and underage drinking. A delinquent offense is an offense that would be a crime if committed by an adult. For instance, the most common status offenses handled in juvenile courts are underage drinking, truancy, and running away from home. In most cases, juveniles commit more property offenses than violent offenses. Juvenile delinquency. The concept of juvenile delinquency is a modern one. Until the late 19th century, juvenile offenders were regarded as incapable of certain crimes or were treated as adults in the criminal justice system. The concept began to change in the 19th century when a group of reformers set out to redeem the nation's wayward youth. Platt, 1969, and Lau, 2002. People who violate the law but are not legally adults, defined as those below the age of 18 in many states or countries, can be adjudged delinquent rather than convicted of a crime in juvenile courts. These delinquents might have committed an act that would be a crime if done by an adult. In general, children under the age of 18 are handled by the juvenile court, either as a status offender or as delinquent offenders. A status offense is a violation that can only be committed by a juvenile, such as running away from home, truancy, and underage drinking. A delinquent offense is one that can be committed by an adult, such as serious property crimes, serious violent crimes, robbery, murder, etc. Juvenile court system. Juvenile courts were originally designed as informal welfare agencies that offered counseling and therapy tailored to the needs of the individual offender. The youthfulness of the offender was thought to confer a kind of diminished capacity to commit crime and to make the offender easier to reform than an adult criminal. The juvenile courts were first established in Cook County, Illinois, USA in 1899. The philosophy of the juvenile court is that it should act in the best interest of the child as parents should act. In essence, juvenile courts have a treatment and rehabilitation orientation. In adult criminal proceedings, the focus is on charging the defendant with a specific crime. In contrast, the focus of juvenile courts is often on the psychological, physical, emotional, and educational needs of the defendant, as opposed to the child's guilt in a unique case. Characteristics of juvenile system. To understand the functioning of the juvenile justice system, it is necessary to know the characteristics of juvenile justice system. The philosophy of juvenile court is that it should act in the best interest of the child as parents should act. The main characteristics of the juvenile justice system are discussed as follows. 1. In juvenile justice system, jurisdiction over criminal children had to be removed from criminal court and established in the juvenile court. 2. The early conception of the juvenile court proceeding was one in which a fatherly judge touched the heart and conscience of the erring youth by talking over his problems. 3. The juvenile court had broad jurisdictions, and no juvenile court confines its definition of delinquency to violations of laws and ordinances. 4. In the juvenile justice system, the juvenile court was not a criminal court. Instead of criminal procedure, a non-adversarial proceeding was used, which took the best interest of the child fully into consideration. 5. In the juvenile justice system, children coming under the jurisdiction of the juvenile court were often removed from the custody of their parents without notification and placed in institutions. 6. Youths under the jurisdiction of the juvenile court must be afforded their due process rights, such as a. Adequate notice to parents and child, b. The right to legal counsel, c. The right to confront and cross-examine witnesses, d. Guarantee against self-incrimination. 7. In juvenile justice system, the juvenile court has jurisdiction over children who commit offenses such as running away from home, being out of parental control, or failing to attend school. These are not grave offenses because the children are minors. These children are labeled status offenders. 8. Juvenile justice system provides treatment and rehabilitative measures to correct and prevent crime and delinquent behavior from recurring. Criminal justice system. The criminal justice system has been described as a funnel that sorts out cases. It is a modern society's system of roles and activities for defining and dealing with crime. The criminal justice system is composed of the police, the courts, and the correctional system. However, Zastrow, 1996, observed that criminal justice systems face a conflict between two goals: crime control versus due process. Crime control involves the need to curb and protect society from lawbreakers. It includes an emphasis on speedy arrest and punishment for those who commit crimes. Due process, on the other hand, involves the need to protect and preserve the rights and liberties of individuals. Differences between juvenile and criminal justice systems. The differences between the juvenile and criminal processes are identified below, according to Barlow, 2000. 1. A petition is a formal request for the court to see whether it should take jurisdiction over a case involving a juvenile. 2. In criminal courts, formal charges are read during an arraignment. In juvenile courts, there is an intake hearing where the court determines whether the alleged fact about the crime warrants further action by the court. 3. The criminal trial is an adversarial process. Prosecution and defense battle over their visions of the truth. Although lawyers for both sides often claim victory, the adversarial process implies winners and losers. For the prosecution, conviction is victory, while for the defense, acquittal is victory. This adversarial is reflected in the wording of the case. 4. In juvenile courts, the case is referred to as regarding or in the matter of. There is no sense of context or friction or rift. In addition, since the juvenile court process was designed to be non-adversarial, the constitutional guarantee of the due process was thought to have little relevance in this environment. Juvenile has no right to counsel, no right to question witness, and no right to self-examination. 5. In juvenile court, children are not asked whether they admit or deny the fact alleged in the petition. If they admit the fact, the juvenile court judge will say that the case has been adjudicated and the facts are stated in the petition. If they deny the alleged fact, there is a heading during which the judge reviews the evidence presented and adjudicates the merits of the petition. If the judge finds in favor of the petition, the child is not convicted as a criminal, but is adjudicated. 6. After conviction of a felony crime in criminal court, the judge usually orders a pre-sentence investigation. In juvenile courts, the judge asks the juvenile probation department to develop a social history of the child, including such things as family history, education, education progress, medical history, and police record. Instead of passing sentence, the judge enters a dispositional order, a term that does not imply punishment, although the juvenile may be placed in detention or be required to do something they perceive as punishment. 7. Another way by which juvenile procedures differ from criminal justice. 7. Another important way by which juvenile procedures differ from criminal justice experienced by adult offenders concerns record keeping and privacy. Consistent with the philosophy of shielding the child, juvenile court records are sealed, and many states resist access to juvenile police record. For many years, most states forbade the police to take photograph or fingerprints of juveniles taken into custody. The term arrested was reserved for adult suspects. This does not mean that there is no record keeping in the juvenile justice system. Police incident reports are kept on a file because they are needed to develop a case. Juvenile justice reforms. Reforms are necessary because critics of the juvenile justice system outnumber supporters, and various efforts to reform the system are considered. In this section, we are going to consider two major juvenile justice reforms, such as 1. Due process reforms. 2. Reform in handling serious juvenile and violent juvenile offenders. Each of these reforms will now be discussed according to Barlow 2000. Due process reforms. This reform dates back to the 1950s and early 60s. In this reform, the juvenile court was meant to be non-adversarial, everyone working instead towards the best interest of the child. The first major due process reform came with the U.S. Supreme Court's ruling in Kent v. United States, 1966, that the juvenile court must be provided the essential due process when transferring juveniles to the adult system. These due process rights include 1. Adequate notice to parents and child. 2. The right to legal counsel. 3. The right to confront and cross-examine witnesses. 4. Guarantees against self-incrimination. The decision was responsible for overhauling the juvenile court system by forcing the courts to establish new legal procedures that respected the child's due process rights. Reforms in handling serious juvenile and violent juvenile offenders. In 1994, U.S. Congress called for a new national strategy to address the problem of rising rates in violent delinquency. In 1996, the Coordinating Council on Juvenile Justice and Delinquency published a National Juvenile Justice Action Plan, headed by U.S. Attorney General Jared Reno. In 1994, U.S. Congress called for a new national strategy to address the problem of rising rates in violent delinquency. In 1996, the Coordinating Council on Juvenile Justice and Delinquency published a National Juvenile Justice Action Plan, headed by U.S. Attorney General Jared Reno, composed of 9 representatives of the federal government and 9 juvenile justice practitioners appointed by Congress and the President. The Council concluded that while the future of the nation's children rests in the local community, states and local initiatives are to reduce violence and present delinquency and to increase capacity of the juvenile practice systems. In this respect, the following reforms were made. 1. Most serious and violent juvenile offenders are being removed from the juvenile justice system in favor of criminal court prosecution. A majority of states have added new crimes to the list of offenses for which juveniles may be transferred to the criminal court. 2. Traditional confidentiality provisions are being revised in favor of more open proceedings and records. In the 1990s, debates over the protection of the juvenile versus the protection of the community and over the juvenile right to privacy and the common right to know was being resolved in favor of the common. For instance, local police and community have the right to know the identity of any potential threat to public order. There are various ways that states are opening up juvenile records and revealing confidential juvenile records for proceedings. Some are allowing juvenile court proceedings to be published. Some are releasing the names of offenders. Most now allow photos and fingerprints of offenders to be deposited in criminal history file. A few states now prohibit the sealing or removal of records and roughly have the state central repository of juvenile case records. 3. State correctional administrators are faced with increasing pressures to develop new programs for juveniles. Since nearly all states now send juveniles sentenced as adults to the Department of Correction, this means that there are more young inmates whose need and vulnerability require special attention. In some states, a special category of youthful offenders have been identified to distinguish more serious offenses from their delinquent peers. Although they have committed serious crimes and are housed in secure facilities, they are offered more extensive programs and services than their adult counterparts. Causes of crime and delinquent behaviors. The explanations of the sources and causes of crime and delinquent behavior are varied and more complex. In this section, 7 out of the many causes of crime and delinquency will be discussed. Each of these will now be described briefly. 1. Family background of offenders. One factor that has received the most attention by researchers is the relationship between delinquency and problems in the child's family system. Some studies have shown that family conflicts, tension, and disruption, family disorganization, lack of parental control, parental rejection, inconsistent and inappropriate discipline, and child abuse appear to cause juvenile delinquency. Free, 1991. In line with Free 1991's findings, there are less delinquency among those youths whose parents value, love, accept, and spend time with them. Barnes and Farrell, 1992, and War, 1993. In contrast, rates of delinquency are higher among those youths whose parents define them in negative terms or abuse them. Matsuda, 1992. The rates of delinquency are also higher among those whose families are disrupted by severe conflict, unemployment, and divorce. Free, 1991. Romo and Falbo, 1992. When there are poor relationships in the family, parental moral and emotional authority is weakened. The diminished authority tends to weaken children's bonds to the social order and increases the likelihood of delinquency. Browning and Loba, 1999. 2. Peer influence. This is another causative factor that has also received the most attention associated with delinquency. This influence has led to the development of juvenile gangs, which has become a significant problem in many of our nation's cities. Learning to commit crime often occurs within groups or gangs, but many adolescents learn not to be delinquent from their peers. Those who are concerned with their reputation and believe they have an investment in abiding by the law cite the influence of their peers as a major reason for not violating the law. Rogers, 1977. However, adolescents who do not have a stake in conformity sometimes join gangs and learn criminal motives and skills from peers who encourage and reward violation of the law. In gangs, adolescents gain respect for older criminals, develop specific skills such as car theft, learn to cooperate with other offenders, and become aware of fences, receivers of stolen goods, shady lawyers, bondsmen, corrupt politicians, and police officers. Rotic, Torres, and Garrett, 1977. 3. Alcohol and drug use. Alcohol, drug use, and crime are strongly correlated with one another. They are factors that are often present when crimes are committed, but do not actually cause crime. Collins, 1981. The high frequency with which these factors are present during crimes suggests that they are facilitating factors that increase the chance that a situation will lead to criminal violence or theft. Some studies have shown that alcohol is present in a significant proportion of homicides and assaults and a small proportion of rapes. Dawson and Langan, 1994. Alcohol also seems to play a role in various sex offenses. Another explanation of why alcohol use is linked to crime is that people who are actively involved in a life of crime rely on alcohol to reduce their anxiety or build up their courage for the crimes they plan to commit. Collins, 1981. Tunnell, 1992. Drug use is clearly associated with greater involvement in criminal activities. There is a high correlation between drug use, especially cocaine use, and being booked for property and violent crimes. Harrison and Gifora, 1992. The greater amount of drug use by offenders does not tell us the reason for the association between drug use and crime. Offenders might purchase expensive drugs. They might have their crimes facilitated by the effects of the drugs. However, drug users are more likely to be arrested because they are known by the police to be criminals, or because the drugs affect their behavior in ways that draw the attention of the police. 4. Lack of employment opportunity for youth. Unemployment is related to crime in complex ways. Some crimes cannot occur unless a person is working, but other offenders mix employment and crime by moonlighting in crime, that is, by using a job as a front, as with a professional fence receiver of stolen goods, or by using legitimate income as a stake for a crime, as in drug deals. Some people, especially youths, alternate between employment and crime, and in those cases, more unemployment might increase. Heshdon, 1994. Some offenders are committed to crime as a source of income. For instance, they would not work even if jobs were available, and so a higher unemployment rate would not affect their criminal activities. People who are without jobs seem more likely to commit the kinds of crime that lead to imprisonment. Austin and Irwin, 1990. Crime also occurs at work. For instance, sudden loss of a job or conflict with a supervisor sometimes leads to violent crime against those thought to be responsible for the employee's problem. Youth's lack of access to jobs that provide the income they need to participate in peer group activities and to buy clothes and other things that will win them respect from their friends are sources of delinquency. Some delinquency is also situational. For example, among homeless youths, unemployment and problems of shelter may lead to prostitution, and problems of shelter and hunger may lead to serious theft. McCarthy and Hagan, 1992. 5. Psychological views of the criminal personality. Crime is seen simply as a manifestation of a compulsion derived from unresolved conflicts between the superego and the id. Someone with criminal personality, by definition a defective ego, is unable to overcome the desire to defy social taboos. Yet, the conflict reflects itself in an unconscious desire to be taught. This indicates that delinquent behavior results when the restraining forces in the superego, one's self-ideal, and the ego, mediator among superego, the id, and reality, are too weak to curb the id, source of psychic energy. Human nature was therefore seen as largely determined by id instincts, which were basically antisocial and immoral in character. This shows that current behavior was largely controlled by early childhood experiences. Deviant behavior or crime was viewed as stemming from unconscious conflicts, fixations, and repressed traumatic experiences. Zastro, 1996. 6. Social views of criminal behavior. Another perspective suggests that crime is not caused by individual physical or mental deficiencies, but rather by societal breakdown. For instance, some studies have shown that family conflict, tension and disruption, family disorganization, lack of parental control, and child abuse appear to cause juvenile delinquency. Free, 1991, observed that there is a weaker link between broken homes and delinquency, and those social, economic, and environmental factors, including poverty, racism, socialization in criminal attitudes by family or peers, and lack of educational achievement, may also be involved in juvenile delinquency. The social view of crime advocates a criminal justice system that offers a variety of social intervention strategies. Cullen, 1983. One of such strategies of importance to social work practitioners is collaboration between social workers and police officers at the earliest intervention point. That is, when the suspected offender is first in police custody, social workers and police officers are expected to agree on the case disposition. 7. Economic rationale of crime. This view sees the criminal as an amoral person who calculates the costs and benefits of a particular crime, much as a business person calculates the costs and benefits of opening a new store. In the economic formulation, potential criminals assess the probable benefits of successful completion of the crime. They decide to be criminal or not, depending on the outcomes of the calculations. For instance, people who are not poor commit fewer crimes because the costs of going to prison in lost wages, deprivation of status, amenities of life, etc., are higher for them than for others. Study session summary. In this study session, we discussed the concepts of crime, juvenile delinquency, juvenile court system, and criminal justice system. We also discussed the characteristics, types, sources, and causes of crime, as well as identify the roles played by the components of criminal justice system. That ends study session 1. Thank you for listening.